Hello. Thank you for your interest in the Minnesota Tribal State Agreement. We hope that this training provides a solid foundation for those of you who are either currently working in tribal or county child welfare or are students interested in working in the field.
My name is Aaron Geary. I coordinate community projects for the University of Minnesota Duluth Department of Social Work, Center for Regional and Tribal Child Welfare Studies. I will serve as the narrator for this module. The module should last about 40 minutes, and you are welcome to stop the slides at any point. There are additional resources available on the homepage of this module. Before I get started, I wanted to thank some of the individuals who helped with the creation of this module. Thanks to Lindsay Rice, who serves as a graduate assistant for our center, to Andrew Small, Indian Child Welfare Attorney with Blue Dog, Paulson, and Small, and to the Center Curriculum Development Committee made up of Ann Tellett and Muscatee Montano. Finally, I wanted to say a big thank you to the 3 individuals who agreed to be interviewed for this project. I will say a little bit more about them in a second, but they are Kim Momaday, Paula Woods, and Evie Campbell. As I said earlier, this module was created with the intention of providing practitioners and students with a strong background and practice knowledge of the Minnesota Tribal State Agreement. I would encourage those working in the field to see this as an accompaniment to a thorough reading of the text of the Tribal State Agreement, not a replacement of it. Despite being a legal document, the TSA is a very readable document, and expertise in the agreement and its inner workings will really come from multiple readings of the agreement itself.
There were 3 interviews conducted for this training. The entirety of all 3 of these interviews are available for viewing on the module homepage, and I recommend taking the time to watch the entire interviews. I've tried to pull out clips from each of the interviews that are relevant to specific parts of the training and to use these clips throughout. I think each of the interviewees brings a unique perspective to the training. Kim Momaday, who currently serves as Assistant County Attorney for Hennepin County, was active in the development of the 2007 amendments to the Tribal State Agreement in a role as Child Welfare Attorney for the Leech Lake Band of Ojibwe. Paula Woods, who serves as the Director of Family and Children's Services for the Red Lake Nation, brings a practitioner's perspective to the training. Paula has used the Tribal State Agreement frequently in her work. Finally, Evie Campbell, Assistant Professor in the UMD Social Work Department, recently had an article published on the development of the Minnesota Tribal State Agreement. Evie will talk about the development process from the perspective of those individuals she interviewed for her research. Before I begin discussing the workings of the Minnesota Tribal State Agreement, I think it's important that I give some brief historical context, as well as some background on some of the other important laws impacting Minnesota's American Indian children and families. As the introduction to the Tribal State Agreement states, from a historical perspective, the majority of federal policies directed at American Indian people provided an experience which was extremely negative. This is perhaps putting it lightly. The bulk of federal and state action historically has been focused on either the termination of tribal peoples or the assimilation of these individuals into Western non-native ways of life. For much of the last century, the American Indian family has been the focus of these actions. In Minnesota, prior to the passage of the Indian Child Welfare Act in 1978, 1 out of every 4 American Indian children under 1 year old was adopted out of their family. The vast majority of these children were placed in non-native homes. As Judge B.J. Jones writes, a common ground for removal was that the natural parent had left the child with an extended relative for a prolonged period of time. To the non-Native American social worker ignorant of the traditional ways of child rearing, such behavior was unacceptable under Anglo-Saxon traditions. This removal has had a devastating impact on the health and survival of tribal cultures and communities. In response to the disproportionate numbers of American Indian children being placed out of the home, the Indian Child Welfare Act was passed in 1978. ICWA was groundbreaking in that it recognized that tribal communities know what is best for tribal children, and it provided a legal framework for social work practice that helped American Indian children establish or maintain their connection with their tribe and family. The ICWA recognized and affirmed tribal sovereignty in child welfare matters. Briefly, some of the key elements of the ICWA are as follows. ICWA established a more intensive process for finding and engaging relatives, known as active efforts. While what active efforts means has been open to interpretation and is actually more clearly established within the Tribal State Agreement, the law notes that this is the highest standard possible to prevent the breakup of Native families. With this provision, ICWA clearly established a due process requirement for removal of Indian children that did not previously exist. The ICWA also affirmed the jurisdiction and authority of Indian tribes over child welfare matters on the reservation, and expanded the role of tribes in cases involving children off reservation. This meant establishing that notification must be provided to tribes when it is suspected that an ICWA-eligible child has come into the care of a state or county child protection agency, strengthening the authority of tribal courts and expanding the ability of tribes to license foster homes and draw down child welfare funding. ICWA also established a hierarchy of placement preferences for eligible children. These preferences established that an Indian child needing to be adopted must be placed in the following settings in order of preference. First, with a member of the child's extended family. Second, with another member of the child's tribe. And third, another Indian family. Although this module does not delve into the nuances of the ICWA, some helpful resources for those of you who would like to gain a more thorough understanding of the law are listed on the module homepage. To strengthen the Indian Child Welfare Act at the state level, the Minnesota Indian Family Preservation Act was passed in 1985. Among other provisions, MIFPA expands on ICWA's call to include extended family, requires use of out-of-home placement prevention services, expands notification to voluntary cases, and clarifies funding ambiguity. The full text of MIFPA is found on the module homepage. The Tribal State Agreement can really be seen as the third component of the legal toolkit for Minnesota Indian child welfare practitioners that includes ICWA and MIFPA. The agreement was passed after a lengthy negotiation process in 1998. Please view the video clip of Evie Campbell for a clearer description of the development process.
They wanted to strengthen what we already had in place, and they wanted to provide a framework for other child welfare practitioners to work with American Indian children and their families. And so the questions had to do with the motivation, why were you doing it, the process, how was it done, and then any recommendations they would give to other people interested in doing the same type of document, the same type of agreement. So with that in mind, the questions were about the process itself, or the motivation itself. Why did they do it? And so interviewing them, I found out that the main reason they were doing it is because when they looked out in their tribal community, they found out that their children were disappearing. There was missing children, and there weren't as many of them. So looking into that further, they found out that the counties were not in compliance with ICWA. They weren't following ICWA. So then they went to the state and said, hey, we know that these counties aren't following the Indian Child Welfare Act, so what can we do to strengthen it? And so they went on to the cumbersome piece of getting this document in place. So speaking with the work group members, it was a 7-year process to actually come together with this agreement.
Before jumping into the key elements of the agreement, it's important to understand the importance and goals of the TSA. Here's a clip from the interview with Kim Amadei that gives a nice description and overview of the agreement.
First of all, I think the Tribal State Agreement was intended to carry out the policy that's set forth in ICWA, which is that the American Indian children and their tribes, the children are the tribe's greatest resource. And the law recognizes that and sets that forth as federal policy. And I think that the Tribal State Agreement was intended to carry that out here in Minnesota. ICWA itself provides for these types of agreements to be enacted between states and tribes around child welfare cases. And so any state can enter into these types of agreements so that they spell out what their process is going to be, what their policy is going to be, how are these cases going to be handled. And so Minnesota decided to do that with the 11 tribes in Minnesota. In this state, which is different from a lot of other states in the country, is that the Department of Human Services, or the state of Minnesota, they're the administrator for child welfare, but the work itself is operationalized and carried out by the counties. And so this area of child welfare becomes very complex when you work in the field and you go from county to county, I'm thinking right now from the perspective of maybe a tribal representative or a tribal attorney having to represent the tribe on cases that may be venued in a different county every week. So that the work itself can be very difficult from that perspective. So this agreement was intended to further the policy, and it was also intended to provide some practice tips, some help and assistance for the counties to have a document that they could look to and find some guidance on how should we go about working with American Indian families that are in the child protection system or in child welfare. And so that, I think, is the broad goal of it, is carrying out that policy and making it specific to the state. And having the tribes in the state come together and be recognized by the state as being a critical player in the child welfare work. And this, I think, is one of the greatest things about the Tribal State Agreement, is that it recognizes that there are other governments in this state, first of all, and that they are very important in how the child is treated in the child welfare system. And it recognizes that tribes are a resource for counties when they have these cases in their court system. And the agreement encourages and urges counties to take advantage of the tribes being resources for kids and being resources for the county system as well, as they make decisions about placement, even investigation.
Throughout the next phase of the module, I'm going to cover some of the specific elements of the Tribal State Agreement. These will include jurisdiction and authority, qualified expert witness, training, and dispute resolution components. This is by no means all of the critical pieces of the agreement, but will hopefully be a chance to get more in-depth knowledge on a few specific elements. Let's start with issues related to jurisdiction and authority. The agreement clearly establishes the co-jurisdictional or dual jurisdictional relationship for cases involving Indian children off-reservation. Additionally, the agreement affirms ICWA's contention that tribes have full authority over their on-reservation members in child welfare matters. With this jurisdictional arrangement comes the necessity to notify tribes when one of their members is involved in a child protection case. Kim Amadei shares some thoughts on the jurisdictional elements of the agreement in the clip that follows.
Right at the very beginning of this document, the Tribal State Agreement recognizes that the tribes have jurisdiction over their own territory. And if there's a child welfare matter that the state needs to investigate within that jurisdiction of the tribe, they should approach the tribe, and if at all possible, and whenever possible, they should join together and conduct those assessments and investigations together. And I think it sets out a really good model for working on these types of cases right at the very beginning, from the time a report's made and a decision made by a human services entity that further involvement is going to be needed here. And it says, engage the tribe as soon as possible and go out together, assess the situation, and confer with one another. So I think that model of encouraging this to happen at the earliest possible stage is so important for this work.
The Tribal State Agreement has specific provisions related to the use of qualified expert witnesses. The qualified expert witness is a provision stipulated by ICWA that states that before a court can order a foster care placement, testimony must be provided by a qualified expert witness. ICWA does not specifically define what qualifications this witness must have, so the Tribal State Agreement provides clarity on this issue. The agreement states that an expert witness must be one of the following: a member of the Indian child's tribe who is recognized by the tribal community as knowledgeable in tribal customs, a lay expert with substantial service delivery experience, or a professional with substantial education and experience. The agreement also clearly states that tribes should have the authority to determine who is a qualified expert witness. The agreement calls for the development of a list of qualified experts for each tribe. This list cannot be disputed by the Minnesota Department of Human Services. The agreement states very clearly that a determination of tribal membership by a tribe is conclusive. This language was intended to bar the use of the existing Indian family doctrine in ICWA cases. This doctrine is being used by some states to give district court the authority to determine the level of connection of a child to his or her tribe, and therefore determining ICWA eligibility not on tribal membership or eligibility for membership, but on a district court perception of a young person's connection to their tribe.
I believe in some states, and I believe, not 100% sure, but I believe this started with guardian ad litem or maybe CASA programs, that the attorney, I believe, for the guardian ad litem made the case that a child was not an Indian child because they did not have significant ties with the tribe. And so they would try to not have it stand as an ICWA case because the child wasn't an Indian child, because they didn't, I don't know, live on the reservation, they didn't speak the language, they had no significant ties to the reservation, those types of things. And that it would be up to the judge to decide whether the child was an Indian child and not the tribe. And tribes all across the nation have objected strenuously to this idea of an existing Indian family doctrine. And so the Tribal State Agreement, the 2007 Tribal State Agreement, included a section that existing Indian family doctrine would not be used to determine whether a child's an Indian child, that the tribe makes those determinations, and not a judge in a court, but the tribe itself.
The need for improved training for DHS and county child protection workers on issues and practice related to American Indian child welfare was addressed through the Tribal State Agreement. The agreement stipulates that DHS must require training related to Indian child welfare law, as well as practice with American Indian families. This slide outlines some of the required areas of content. In the event that a worker or family member files a complaint that the agreement wasn't followed by a county or private child placement agency, a procedure was created to ensure that these complaints are heard in a timely manner and that a process exists to address them. An ICWA compliance team was created to hear, assess, and make determinations when complaints are filed. The review team should be made up of 2 Department of Human Services employees, 2 members of the ICWA Advisory Council, 1 representative from the local social services agency, and 1 representative from a private child placement agency. This review team is required to meet quarterly to assess complaints and make recommendations.
The next phase of the training are 2 case scenarios in which you will be asked to try to apply some of what you know about the Tribal State Agreement as well as other legislation, such as the Indian Child Welfare Act, to a specific case. For these scenarios, please read through the text at your own pace. The next slide contains some questions related to the case. Take the time to write some notes and think about the answers for each of these questions. Try citing specific elements of the Tribal State Agreement that are relevant. Again, take the time to read through the following case scenario and answer the questions on the following slide. Hopefully those felt like helpful case scenarios. I would also encourage you to think through some of the cases you currently have on your caseload and determine which elements of the Tribal State Agreement apply. Now I would like to return to the interviews to highlight some of the strengths of the Tribal State Agreement. Please view the following 2 clips to hear 2 perspectives on the strengths of the agreement.
It's very practical in terms of the joint investigations, qualified expert witness. It sets forth placement preferences. It very clearly helps to analyze a situation where, can I ever deviate from the placement preferences of ICWA? It takes a person through those steps. What to consider. Are the child's needs so great that they cannot be met in a family home or in a family member's home, that they must be met in a different type of a facility? And if so, is there someone who can testify to that need? But it specifies the particular findings that have to be made before this deviation from ICWA should take place. So I think it's a very practical document that provides some helpful guidance for practitioners.
But like, if I didn't believe a county worker was really doing active efforts, I would fax that page on the definition of active efforts to them, along with, probably the statute or pertinent statutes for MIFPA and ICWA, and maybe even a section from the DHS Social Services Manual. Here's what we're requesting. Here's what the law says you need to provide. Why isn't this being done, or when will you get it done, type of thing. Depending on, how far gone you are. Usually if it's at the beginning, sometimes it's just, oh, I didn't know this, and they'll talk to their supervisor, and then things will go differently. But if you've been struggling with it for a while, then you talk about it a little bit more sternly. Sure. This isn't really a request, this is the law, and you need to follow the law. And it's surprisingly successful. So I really think a lot of it is, if it's not in front of them, if it's not something that they deal with, they don't know. The workers might not know.
While the Tribal State Agreement is seen as an important document for promoting best practices, the interviewers also noted that it is not without implementation challenges and areas that should be strengthened. Once again, view the following clips for 2 perspectives on the challenges related to the agreement.
one of the challenges is that this is a tribal and a state agreement, and that it was signed by the state and the 11 tribes. And I think one of the barriers toward its effectiveness is that the counties, and I'm not sure what happened along the way here with the county engagement, but I think that some counties have been reluctant to apply the tribal state agreement in the work that they do with American Indian families, just for that reason, being that they were not at the table as parties or partners in this joint venture that was engaged in by the state and the tribes. And so I think there's some reluctance to adhere to it and find that, okay, this is a document that applies to this entity as a local entity, because it was not that local government entity that entered into it. I think that's one obstacle to implementation of this agreement across the board, across the state of Minnesota, I would say. Secondly, I think that for counties, or when there's been a violation of ICWA or MIFPA, what is to happen with that kind of a violation? So I think one of the weaknesses of it is that when the report is made to DHS that there's been a violation, most of the time, hopefully, and I don't have data on this because that's not the work that I've done and work that I'm doing right now, but hopefully most of the time the system has been responsive so that those issues of concern, when there's been a violation or some kind of a dispute about a case, hopefully they've been resolved amicably between the parties. But for those that aren't, what happens with that? So that, let's say if another ICWA case occurs in that with those same players, is their interaction going to be the same, or is it going to be different because they learned some things in that first process? And I just think that the agreement doesn't reach that far to say, okay, here's how we're going to address any violations. And I think what happens is, and what it states is that parties are free to resort to or take advantage of legal avenues that are available to them to address a violation of ICWA.
Well, I mentioned the joint investigations, and every county is different, and because the state of Minnesota is one of those 13 states, I believe, that deliver social services through a county system, and those counties have a lot of ability to define how that system is delivered. So we have 87 counties. You could have 87 different ways of delivering it. And certainly when I worked at Leech Lake, every one of the 4 counties that we dealt with the most did it differently. So that can be pretty burdensome to tribes to have to figure out, if we've got, here at Red Lake, we know how we do things in Red Lake, and we're pretty familiar with how Beltrami County does things and how Hennepin County does things, but we've had to deal with counties that have never had an Indian child welfare case before. They don't know anything about the Indian Child Welfare Act. They don't know about the Minnesota Indian Family Preservation Act. They don't know about the Tribal State Agreement. And they don't know what the provisions in their own social services manual is about that, because they've never even had to look at it before. So that can be pretty interesting. And I would say for the most part, it's just ignorance, and it's not that they're unwilling to follow it, but they just didn't because they didn't know. And the training is supposed to exist within the core, so, the DHS Social Service Core training, so that there would be no reason that they wouldn't know that, but they still don't for however that happens. So tribes have to know how to deal with all these different entities, and that can be challenging. They don't have the resources, they don't have the staff to do it.
As you continue your practice in child welfare, I would encourage you to see the Tribal State Agreement as an important tool for good casework with American Indian families. During your reading of the Tribal State Agreement, think about how this document, along with other legal tools, could help address the existing disproportionate rate of out-of-home placement experienced by American Indian children. As hopefully was clear from the training, the Tribal State Agreement represents a historical, legal, and grassroots victory for American Indian child welfare practitioners in Minnesota. The document contains several components that strengthen and clarify the Indian Child Welfare Act and provide a blueprint for state and tribal engagement in child welfare. I want to close with a final clip from Kim Amadei, who describes the agreement and its importance more eloquently than I could.
The tribe is an excellent resource, I think, and having that stated in so many ways throughout the document is critically important. Now, I think that what happens sometimes is people wonder, why should this other entity have such great involvement in this case that I'm responsible for? And the agreement itself, I think, if a person would just read through it, provides a perspective, and that perspective is that the tribes can offer assistance. The tribes can bring an additional resource into this case, and furthermore, it's the best interest of the child. And whether you're a Native American or someone from a different cultural background, this work demands that we consider the best interest of the child. And so it provides a perspective on what is this Indian child's best interest. And that's always going to include who they are as a tribal member. And when you kind of add that lens to your perspective, I think it opens up a world of possibilities for you. You say, okay, I'm thinking about the child, and I can stop worrying about another entity complicating this complex case from the beginning, but rather I can look at serving the needs of this child. And one of the things that's going to benefit them the most is going to be maintaining their sense of belonging to their family and to their tribe. That's going to benefit them long term for the rest of his or her life. So, this is the perspective that tribes bring to these cases. They bring the long view. They bring the lifespan view. They're not thinking about, I have to put a lot of effort into this case for 6 months, and then it's going to be a permanency case. I think that's one view, and it's certainly maybe a legal perspective to know, okay, I have to get certain things done and completed and be timely about the things that I do and meet the guidelines that the law requires me to do. But over here, on top of this, is the Indian Child Welfare Act, which mandates certain things, one of them being the involvement of the child's tribe. And the reason for that is what I just said. That's what's going to benefit this child over the child's span of life, not just 6 months, not just until there's a permanency decision made or until the case is closed, but that involvement is going to benefit the child even beyond that. And so when we think of the children's best interest, we have to understand that this view of best interest of the child for this American Indian child is always going to include their tribe. It's even going to include the community they came from, that geographic landscape that they grew up in.